Cut it. Old ranchers don't get to block a whole neighborhood. That was what Marlene Whitaker said while her maintenance guy snapped the lock off my pasture gate. The chain dropped into the dirt. The gate swung open, and two white SUVs rolled straight toward 40 acres of my cattle land. Marlene stood beside the gate in designer sunglasses, holding a printed emergency access notice like it was a court order. Behind her were two HOA board members. One had his phone out, recording me like I was the criminal. And before I even stepped out of my truck, Marlene had already called the sheriff. She told him I was blocking a lawful easement. She told him I was endangering families. She told him I was refusing emergency access. I did not yell. I did not grab the bolt cutters. I did not slam the gate. I just took one picture of the broken chain. One picture of her white Lexus parked inside my fence, and one picture of the trail camera watching all of it from the oak tree. Marlene thought the word easement gave her power. She had no idea that one sentence in my grandfather's deed was about to turn her emergency access claim into a trespass report. And she had no idea that the $1,200 she had charged every homeowner for access improvements would become the worst mistake of her presidency. 20 minutes later, Sheriff Dean Harlan opened the county record on the hood of his cruiser. He looked at Marlene. Then he asked the question she had never bothered to answer. "Ma'am, who owns the land under this gate?" That was when her smile disappeared. And that was when everyone finally understood. This was never really about a gate. It was about a woman with a clipboard trying to turn my family's pasture into her HOA's private road. My name is Caleb Mercer. I am 62 years old. For 27 years, I worked as a county surveyor. I measured boundary lines. I checked plats. I read deeds. I found old iron pins buried under roots, gravel, and 50 years of bad assumptions. Most of my job came down to one simple truth. A map you wish was true does not beat a deed that is recorded. The land Marlene wanted was part of the old Mercer pasture. 40 acres of grass, oak trees, creek bottom, fence posts, and cattle. My grandfather bought it when this county still had more cows than cul-de-sacs. His name was William Mercer. He was not a rich man. He fixed tractors. He raised cattle. He patched his own roof. But he understood land. He used to say, "A man who doesn't know his boundary will spend his life arguing with someone who does." When I was 9 years old, he walked me along the north fence line. He showed me an iron pin half buried under moss. He made me kneel down and touch it. Then he said, "That little piece of metal is quieter than any lawyer, and stronger than any loudmouth." At 9, I did not understand. At 62, standing beside a cut lock while an HOA president accused me of stealing access from her neighborhood, I understood perfectly. The pasture gate sat on the east side of my land. An old dirt lane came in from County Road 18. It crossed part of my pasture, curved past a utility pole, and ended near a water tank. The lane had been there for decades. It was not paved. It was not pretty. After rain, it turned soft and rutted. In August, it turned to dust. Most days, it had cattle tracks and manure on it. It was a pasture lane, not a neighborhood road. The easement language was clear. Limited access for utility maintenance, emergency services, and agricultural use. That was it. No public access. No residential traffic. No subdivision shortcut. No HOA authority. For years, nobody cared. The utility company had its own lock on the chain. The fire department had a Knox box on the gate. The county knew the procedure, and I kept the gate locked because there were cattle inside. Then Stonebridge Estates arrived. At first, it was just survey flags and orange stakes across the old Miller property next to mine. Then came the bulldozers. Then the model homes. Then the fake stone entrance sign with uplights and imported shrubs. Stonebridge Estates, a luxury community with lakeview lots, custom mailboxes, and rules about trash cans, fence colors, garage doors, and how long a work truck could sit in a driveway. I was not part of Stonebridge. I had never signed their covenants. I had never paid their dues. My land was outside their plat. But from the first week people moved in, Marlene Whitaker acted like my pasture was unfinished HOA business. I met her on a Tuesday morning in March. I was replacing a hinge on the pasture gate when a white Lexus stopped behind my truck. Marlene stepped out wearing cream-colored slacks and boots that looked personally offended by the mud. She looked at the gate, then at the cattle, then at my old truck, then at me. "You're Mr. Mercer?" "That's right. I'm Marlene Whitaker, HOA president for Stonebridge Estates." I nodded. She waited for that title to do something. When it didn't, her smile tightened. "We're reviewing community access and emergency safety compliance for the area." I wiped grease off my hands with a rag. "This isn't your community. She gave me a small laugh. Oh, I understand you're not technically inside the HOA. Technically. That was the first warning sign. But your gate is blocking an easement that affects our residents, she said. We'll need a key. I looked at her. A key to what? To the gate. This gate? Yes. No. Her smile disappeared for half a second. Then it came back sweeter. Mr. Mercer, I don't think you understand. This is a safety issue. If emergency vehicles need access, we can't have a private citizen deciding whether the gate opens. I pointed to the small black box bolted to the post. Fire department already has access. She glanced at it. What is that? Knox box. Fire chief has the key. Utility company has its own lock. County knows the procedure. The HOA needs access too. No, ma'am, it doesn't. The easement serves the area. The easement serves specific purposes. That sounds like semantics. That sounds like a deed. She stared at me, like I had spoken a language she did not respect. Then she looked me over again. My faded flannel. My mud boots. My cracked windshield. Mr. Mercer, she said, this neighborhood represents a significant investment. We can't let outdated rural habits interfere with modern safety standards. Outdated rural habits. That was what she called my family's land. I should have known right then that she was not going to stop. The first letter came 10 days later. It was printed on Stonebridge Estates HOA letterhead. The title said, Notice of Easement Obstruction. It claimed my gate was blocking a community emergency access corridor. It said the HOA had authority to require immediate access. It said failure to comply could result in reporting the matter to county authorities. At the bottom, in bold letters, it demanded that I provide the HOA with a gate key within 7 days. I made coffee. Then I carried the letter to my kitchen table and opened my deed folder. Not because I was scared, because I had been a surveyor too long to trust anyone who used the word easement without quoting the language. I found the 1974 deed. I found the recorded easement. I found the county plat. Then I wrote Marlene a polite response. I explained that the lane across my pasture was a limited-use easement. It was for utility maintenance, emergency services, and agricultural purposes only. I explained that Stonebridge Estates was not named as a beneficiary. I explained that no HOA officer, board member, resident, contractor, visitor, delivery driver, or private vehicle had permission to use that lane. Then I included copies. I sent it certified mail. For a reasonable person, that should have ended it. For Marlene Whitaker, it was only the beginning. The next Saturday, I found a laminated notice, zip-tied to my gate. HOA safety review pending. I cut it off and saved it. 2 days later, a man in a Stonebridge security polo parked at my gate and started taking pictures. So I took pictures of him taking pictures. The following week, I received an email from a neighbor inside Stonebridge. His name was Tom Alvarez. I did not know Tom well, but I knew his truck. He was a retired firefighter. He was also one of the few people in that subdivision who still waved like a normal human being. His email said, Caleb, just thought you should know. Marlene told the board your pasture lane is supposed to become our second emergency entrance. She says you are refusing to cooperate and putting residents at risk. Some of us asked for documentation. She said the documents are being finalized. Then he added one more line. She also mentioned a new access assessment, $1,200 per home, supposedly for signs, grading, and future emergency route work. I read that twice. Documents are being finalized. Access assessment. Future route work. Easements are not finalized by HOA presidents after a subdivision is built. They are recorded. Or they are not. And no board can vote a private pasture into a neighborhood road just because the shortcut is convenient. So I started a file. That was something I had done for other people for 27 years. Now I was doing it for myself. I put every letter in order. I printed every email. I photographed every sign they taped or tied to my fence. I checked my trail cameras every night. And I called Denise at the county clerk's office. Denise had worked behind that counter since before half the county knew what email was. When she heard my voice, she sighed. Caleb, please tell me Stonebridge is not trying to claim that pasture lane. So, you've heard. They requested copies of old plats last month. Then their attorney's assistant asked whether an HOA could enforce a private easement if it served neighborhood safety. What did you tell them? I told them to hire a real estate attorney and read the recorded document. That probably wasn't the answer they wanted. No, she said. It was the answer they needed. That afternoon, I drove to the courthouse and paid for certified copies. The deed, the easement, the original Miller Tract plat, the Stonebridge subdivision plat. That night, I spread everything across my kitchen table. The story was clear. My grandfather's pasture lane existed before the subdivision. Stonebridge had been built next to my land, not through it. Their official plat showed one entrance, Stonebridge Drive, connecting to County Road 22. No secondary entrance. No HOA road across Mercer Pasture. No community access. But then Tom forwarded me a glossy sales brochure for Stonebridge Phase 2. That was when I saw the motive. On the brochure, a faint dotted line ran along my pasture lane. It was labeled, Future Emergency and Resident Access. Not proposed. Not pending. Future. As if my land had already agreed. Stonebridge Phase 2 had 18 premium lots at the back of the subdivision. Those lots were far from the main entrance. Residents had to wind through narrow streets, pass the clubhouse, loop around 2 cul-de-sacs, and come out on County Road 22. But if they could use my pasture lane, they had a straight shot to County Road 18. 5 minutes saved. Higher lot values. Better sales pitch. And no need to buy anything from me. That was what the broken lock would eventually be about. Marlene was not just confused. She was selling something she did not own. Before she cut the lock, she tried every softer form of pressure she had. At the April HOA meeting, she put my name on the agenda. Tom called me afterward. She called you a holdout, he said. A holdout from what? Progress, apparently. He sounded embarrassed. She said your gate creates a bottleneck for emergency planning. She said the board has a duty to protect residents. Did anyone ask why the fire department already has access? I did. What did she say? She said the matter involves legal complexities residents don't need to worry about. That is a sentence people use when they don't want questions. The next letter came from a law office 2 counties over. It was more polished than Marlene's letter, but not much smarter. It said the HOA believed it possessed access rights under historic easement principles. It said my refusal to provide a key could be viewed as interference. Historic easement principles. I read that phrase 3 times. It sounded like someone trying very hard to sound legal without saying anything specific. I wrote back again. This time, I included the exact easement language, highlighted. Then I added one sentence at the end. Any attempt by Stonebridge Estates HOA, its agents, contractors, residents, or officers to cut, remove, bypass, or interfere with the gate will be treated as trespass and property damage. I copied the sheriff's office. Not as a threat, as a record. Before that point, all I had were letters, signs, rumors, and threats. That was not enough to spend thousands of dollars dragging an HOA into court, but it was enough to make a clean record. Sheriff Dean Harlan had known me for years. He had been a deputy back when I was surveying county drainage projects. He knew I was not excitable. He knew I did not call unless something had already crossed a line. The next morning, he called me. Caleb, you expecting trouble? I'm expecting stupidity, I said. Trouble depends on whether they bring tools, he sighed. Stonebridge? Stonebridge. Whitaker? Whitaker. Another sigh. She called last week, asking if we would remove a gate from an emergency easement. What did you tell her? I told her we don't remove gates based on HOA complaints. I told her to bring a court order. I looked out my kitchen window toward the pasture. And she asked what would happen if the gate was already removed when we arrived. That was the second time my stomach tightened. After that, I prepared. I did not provoke. I put a new memory card in the trail camera above the gate. I added a second camera facing the lane. I photographed the lock, the chain, the hinges, the no trespassing signs, the cattle fencing. Then I called my insurance agent. I asked him to put something in writing. What would unauthorized residential traffic through an active cattle pasture do to my liability? He sent the letter the next day. It said exactly what I expected. Unauthorized use of the pasture lane by HOA residents could increase liability exposure. It could create livestock escape risk, and it could affect coverage if I knowingly allowed uncontrolled access. That letter mattered, because if one of those SUVs spooked the herd, and a cow broke through the fence, Marlene would not be the one explaining it to my insurance company. I would. So that letter went into the file. Then I drove to the fire station. Chief Randall was outside with a coffee mug in his hand and dust on his boots. He listened while I explained what was happening. Then he shook his head. We've had access for years. I know. Your Knox box works. I know. We don't need the HOA to have a key. I know. He wrote a short statement on department letterhead. It confirmed that emergency access was already handled. It also confirmed that the HOA did not need independent access for fire response. That went into the file too. By then, the file had grown into a binder. That is something people like Marlene never understand. Quiet people are not always passive. Sometimes, They are just organizing the evidence. The public pressure started in May. At first, it was small. A woman in a golf cart stopped by the fence while I was checking the water trough. "You know," she said, "people are saying you're making it unsafe for families." I looked at her. "Which families?" She blinked. "Well, the community." "What emergency happened?" "That's not the point." "It usually is." She drove away. A week later, someone left a note in my mailbox. "Open the road. Stop being selfish." I put it in a plastic sleeve. Then someone posted in the Stonebridge Facebook group. They called me a hostile adjacent landowner obstructing emergency planning. Tom sent me the screenshots. One comment said, "Why should one old rancher get to decide whether our kids are safe?" Another said, "That gate needs to come down." Marlene liked both comments. I printed them. I had learned something in all my years at the county. When people are building a false story, they rarely do it all at once. They do it in layers. First, they rename your property. Then they question your motives. Then they make your refusal sound dangerous. Then, when they finally cross the line, they act like you forced them to. By June, Marlene was ready for the next layer. She called a special HOA meeting and invited me. The invitation said, "Discussion regarding Mercer easement access and community safety." I almost did not go. I was not a member. I had no duty to sit in a clubhouse while people who had moved in 6 months earlier debated my grandfather's land. But Tom called me. "You should come," he said. "She's showing maps." That got my attention. Maps are where liars get confident, and surveyors get interested. So I went. The Stonebridge clubhouse looked exactly like you would expect. Stone fireplace, polished floors, framed pictures of model homes, and a long table where the board sat like they were county commissioners, instead of volunteers arguing about mailbox colors. Marlene sat in the middle. She wore a navy blazer. A thick folder sat in front of her. The room was full. Some residents avoided looking at me. Others stared like I had walked in carrying a problem instead of a deed. Marlene began with a soft voice. "Thank you all for coming. Tonight we are addressing a serious safety matter affecting every family in Stonebridge Estates." She clicked a remote. A map appeared on the screen behind her. It showed the subdivision, the clubhouse, the back lots, and my pasture lane highlighted in bright red. At the top were the words, "Stonebridge Secondary Emergency Access." I folded my arms. That was not a county map. I knew it immediately. The line weights were wrong. The parcel numbers were missing. The easement labels were not formatted like recorded documents. It looked like a developer exhibit. Pretty, expensive, and useless. Marlene pointed at the red line. "As you can see, this access route was always intended to serve our community." Tom raised his hand from the front row. "Is that recorded with the county?" Marlene's smile tightened. "This exhibit reflects the development intent," Tom said. "That's not what I asked." A few people murmured. Marlene clicked to the next slide. "We are not here to get lost in technicalities. We are here because one adjacent landowner has placed a locked gate across a route designed for emergency use." Then she looked directly at me. "Mr. Mercer, would you like to explain why your personal preference outweighs the safety of this community?" There it was. The trap. Not law. Emotion. She wanted me angry. She wanted me defensive. She wanted that room to see the old rancher lose his temper. I stood up slowly. "My personal preference does not matter," I said. "The recorded easement does." Marlene gave a small laugh. Again, technicalities. "No," I said. "Boundaries." The room went quiet. I looked at the screen. That map is not a recorded plat. It is not a deed exhibit. It is not an easement document. It is a marketing map. Marlene's face changed just a little. "Not much, but enough," I continued. "The actual recorded easement allows utility, fire, and agricultural access. Fire already has access. Utility already has access. The HOA does not." A board member leaned toward his microphone. "Mr. Mercer, are you an attorney?" "No," I said. "Retired county surveyor." That shifted the room. Not all the way, but enough for people to look back at the map differently. Marlene recovered quickly. "Then you should understand that land use evolves. Recorded rights do not evolve because a board wants a shortcut," the room murmured again. Marlene closed her folder. "Well, the board has a duty to act. We will not allow one unreasonable neighbor to jeopardize this community." I nodded. "Then make sure your next action is recorded too." I left before the meeting ended. That night, Tom called. "She's furious," he said. I figured. She told everyone the board has authority to remove obstructions from emergency access. Did anyone ask for the court order? I did. And she said action would be taken under HOA emergency powers. I closed my eyes. HOA, emergency powers. On land outside the HOA. A board vote can control HOA property. It cannot create rights across land the HOA never bought. That was when I knew she was going to cut the lock. The only question was when. It happened the following Saturday at 8:17 in the morning. I know the time because my trail camera recorded the first SUV pulling up. Marlene arrived in the white Lexus. Behind her came a Stonebridge maintenance truck. Then two board members. One of them, Preston Vale, stepped out with his phone already recording. The maintenance guy took bolt cutters from the truck bed. To his credit, he hesitated. The camera caught him pointing at my no trespassing sign. Marlene pointed at her paper. Then she pointed at the chain. He cut it. By the time I arrived, the gate was open. The first SUV had already rolled 10 yards into the pasture. I parked across the lane. I did not touch their vehicles. I did not block the county road. I simply stopped any more traffic from entering my field. Marlene walked toward me like she had already won. "You're interfering with authorized access," she said. "You cut my lock. You obstructed an easement. You cut my lock. We have board authorization. You cut my lock." She hated that I kept saying it calmly. Preston stepped closer with his phone. "Mr. Mercer, are you refusing to allow emergency access?" I looked at the two SUVs, the maintenance truck, and the HOA president in designer sunglasses. "Which one of you is the fire department?" He lowered the phone a little. Marlene snapped, "Don't be cute." A calf bawled behind us. One of the cows had pushed toward the far fence, startled by the engines and voices. The herd started bunching near the corner. That made me angrier than the lock. But anger is not useful until it is disciplined. Marlene lifted her chin. "The sheriff is already on his way. I reported you for blocking a lawful easement." "Good," I said. She looked confused. I walked to the oak tree. Then I pointed up at the trail camera. I took a picture of it with Marlene standing in the background. "What are you doing?" she asked, making sure the angle is clear. For the first time that morning, she looked less certain. Sheriff Dean Harlan arrived 20 minutes later. Deputy Morris pulled in right behind him. Dean stepped out of his cruiser and looked over the scene. He did not rush. He did not raise his voice. He looked at the broken chain in the dirt, the open gate, the HOA notice taped to my fence, the SUVs inside the pasture, the cattle pressed near the far fence. Then he looked at me. "Morning, Caleb." "Morning, Dean." Marlene's head snapped toward me. She had not expected first names. That was the first crack. She hurried toward the sheriff, holding her folder. "Sheriff, thank goodness. This man has been blocking our emergency easement for months. Today, the HOA exercised its authority to remove the obstruction, and now he is interfering." Dean held up one hand. "Slow down." But Marlene did not slow down. "We have residents at risk. We have board authorization. We have maps. We have—" "Mrs. Whitaker," Dean said. "Did you cut that lock?" She blinked. "The HOA removed an unlawful obstruction." That was not my question. Her mouth tightened. "Our maintenance contractor removed the lock under my direction." Deputy Morris wrote that down. I saw Marlene notice. Her voice changed. "Sheriff, with respect, the lock is not the issue. The easement is." Dean looked at me. "You have your documents?" I reached into my truck and pulled out the binder. Marlene laughed. "Oh, wonderful." He brought a scrapbook. Dean did not laugh. He took the binder and opened it on the hood of his cruiser. That hood became the courtroom Marlene had not prepared for. I had the documents in order. First, the certified deed, then the recorded easement, then the county plat, then the Stonebridge subdivision plat, then the fire department letter, then the insurance letter, then photos of every prior HOA notice, then screenshots of Marlene's public claims, then the trail camera stills. Dean read quietly. Deputy Morris checked the camera stills. He looked at the timestamp. Then he looked at the broken chain. Marlene tried to fill the silence. "Sheriff, the community has relied on that access representation since purchase. The developer clearly intended." Dean held up one finger without looking at her. She stopped. He turned one page, then another. The maintenance guy shifted his weight. The board members stopped recording. Finally, Dean tapped the certified easement with his finger. "Mrs. Whitaker." "Yes? Can you show me where this document grants access to the HOA?" She stepped forward. She looked at the page like the words might rearrange themselves for her. "It says emergency access. It says emergency services. That benefits the community. It benefits emergency services. That is the same practical effect." "No, ma'am, it is not." Her face flushed. Dean turned the plat toward her. "Who owns the land under this gate?" She gave the answer she had practiced. "The easement serves Stonebridge Estates." Dean looked at her for a long moment. That was not my question. Who owns the land? She looked at the board members. Neither one helped her. Dean tapped the parcel label. Mercer. 40 acres. Private property. Your subdivision boundary ends here. He traced the line with his finger. This lane is on his land. The easement is limited. It gives certain parties the right to access for certain purposes. It does not give your HOA the right to cut a lock, open a cattle gate, tape up your own sign, or send private vehicles through an active pasture. For a few seconds, nobody spoke. Then Marlene said the sentence that hurt her more than silence would have. But we voted on it. Dean closed the binder halfway. You voted to cut a lock on land you don't own? Preston took one step back. The maintenance guy looked at the ground. Deputy Morris kept writing. Marlene swallowed. We voted to protect emergency access. Dean looked at the SUVs in my pasture. Were these emergency vehicles? No answer. Is anyone here from the fire department? No answer. Did you have a court order? No answer. Did Mr. Mercer give you permission? Marlene's voice dropped. He refused to cooperate. Dean said, refusing to give you something you are not entitled to is not a crime. That was when Tom arrived. He parked on the shoulder and walked up slowly, holding a folded stack of papers. Marlene saw him. What are you doing here? She snapped. Tom looked at the sheriff. I'm a Stonebridge resident. I think you need to see these. Marlene's face went pale. Tom handed Dean printed emails. I knew some of them. He had sent me screenshots before, but not all of them. Dean read the first page, then the second. His expression hardened. What is the special access assessment? Marlene answered quickly. That is an internal HOA financial matter. Dean looked at her. You charged residents $1,200 each for access improvements to a road on Mr. Mercer's property? Preston whispered. Marlene. She turned on him. Don't. But it was too late. Tom said, she told us the access was secured. She said the money was for grading, signage, and emergency route preparation. Dean looked at the maintenance truck. Were you here to grade this lane today? The maintenance guy raised both hands slightly. I was told we were removing the lock and measuring the entrance. By who? He pointed at Marlene. Deputy Morris wrote that down too. That little notebook was starting to look very heavy. Marlene tried one last time. Sheriff, this is a civil matter. Dean nodded. Parts of it might be. Relief flickered across her face. Then Dean looked at the cut chain. But cutting a lock can be property damage. Entering posted land without permission can be trespass. Filing a report that leaves out the fact that you ordered the lock cut can become a problem. And charging residents for access you do not have may interest people beyond my office. The relief disappeared. I stood by my truck and said nothing. That was the hardest part for Marlene. Not the sheriff, not the documents, not Tom. The hardest part was that I was not fighting her. She had built a whole story around me being hostile, unstable, selfish, dangerous. But there I was, quiet, organized, and holding the deed. Nothing ruins a false story faster than the person it depends on refusing to act the part. Dean told the SUVs to back out of the pasture. One board member mumbled that he did not know the access was not valid. Dean looked at him. Then you should be more careful what you vote to cut. The maintenance guy picked up the broken lock from the dirt and handed it to Deputy Morris. Marlene objected. That belongs to the HOA now, as evidence of obstruction. Dean stared at her. No, ma'am. It belongs to Mr. Mercer, and now it is evidence of who cut it. That line traveled through Stonebridge faster than any official notice. By noon, half the neighborhood knew the sheriff had not arrested me. By dinner, they knew he had questioned Marlene. By Monday morning, they knew the easement was not theirs. But the bigger collapse came the next week. Dean had referred the matter to the county attorney for review, partly because of the trespass and property damage, but mostly because of the special access assessment. Marlene had collected $1,200 from nearly 80 occupied homes for improvements, tied to a private lane she did not control. The developer had used marketing materials implying future access across my land. The board had authorized physical action based on a right it could not prove. That meant the problem had grown legs. At the county administrative building, Marlene arrived with an attorney. So did the developer's representative. So did half the Stonebridge board. I came alone, with my binder. Tom sat behind me. The county attorney was Rachel Kim. She did not waste words. She placed the recorded easement on the screen. This document does not grant Stonebridge Estates HOA access rights, Marlene's attorney said. The HOA acted under a good faith belief. Rachel looked at him. Based on what recorded instrument? He shuffled papers. The development materials indicate. Marketing materials are not recorded instruments. That was the cleanest sentence of the day. The developer's representative leaned into his microphone. "We may need to clarify that sales brochures are conceptual," Tom muttered behind me. "They weren't conceptual when they took our money." Rachel continued. "The county's concern is threefold. First, unauthorized interference with private property. Second, potential misrepresentation to residents regarding access. Third, public safety confusion caused by private signage labeling a non-public pasture lane as an HOA emergency route." Then she turned to Marlene. "Mrs. Whitaker, did the HOA install signage at Mr. Mercer's gate?" Marlene's attorney touched her arm, but she answered anyway. "We posted a safety notice. Did you have permission?" We believed. Yes or no? No. Did you authorize removal of the lock? We authorized removal of an obstruction. Yes or no? Marlene's jaw tightened. Yes. Did the HOA collect an assessment related to future access improvements? Her attorney finally stepped in. "My client will not answer financial questions without..." Rachel nodded. "The county can request those records formally." The board treasurer looked like he wanted to disappear. Then another board member raised her hand. Her name was Elise. She looked terrified, but she spoke anyway. "I asked Marlene in April whether the easement had been purchased or recorded. She said the county had already approved it." Marlene whipped around. "That is not what I said." Elise opened a folder. "I have the minutes." The room changed. You could feel it. Until that moment, Marlene had been trying to frame the issue as a misunderstanding. Her HOA against one stubborn rancher. But now her own board was producing minutes. Elise read from them. President Whitaker stated that secondary access through Mercer Pasture was confirmed, and that funding would be used to prepare the route. The developer's representative closed his eyes. Rachel asked, "Confirmed by whom?" Elise looked at Marlene. Marlene said nothing. That silence was worth more than any speech I could have given. Over the next 2 weeks, the consequences came one after another. The county issued a written notice confirming that Stonebridge Estates had no right of residential, HOA, or private board access through my pasture lane. The HOA was ordered to remove every sign referring to the lane as community access. The board had to send a correction letter to every resident. Every household that paid the access assessment received a refund notice. The developer had to revise its Phase 2 marketing materials. They also had to send corrected disclosures to buyers who had been told that my pasture lane would become a future access route. My fence repair was reimbursed. My lock replacement was reimbursed. My gate inspection was reimbursed. Even the livestock check was reimbursed. Marlene resigned as HOA president before the recall vote could remove her. The sheriff's office completed its report. I will not pretend she was dragged away in handcuffs. Real life is usually slower than that, and much heavier on paperwork. But the report documented everything. The cut lock, the unauthorized entry, the false framing of the sheriff call, the board authorization, the assessment, the claim that was never supported by a recorded document. For someone like Marlene, that was almost worse than being yelled at. A public record she could not talk over. A document she did not control. A version of events written by someone who had stood at the gate and asked who owned the land. Stonebridge changed after that. Not overnight. People who had repeated Marlene's story did not all apologize at once. Some avoided me. Some pretended they had always had doubts. A few doubled down quietly, because pride can survive facts longer than most people think. But Tom came by one evening with 2 coffees. We stood by the repaired gate. "I owe you an apology," he said. "You weren't the one with bolt cutters." "No," he said, "but I was in the room when she called you selfish. I should have pushed harder." I looked across the pasture. The cattle were calm again. The gate hung straight. The new chain was heavier than the old one. "You brought the emails," I said. "That counts." He nodded. "She had people scared. Made it sound like if we didn't get that road, ambulances would be trapped. That's how fake authority works," I said. "It borrows real fears." He looked at the sign. "County is putting up the new one tomorrow morning." The next day, a county truck came out. The crew installed a proper sign. Not something printed in an HOA office. Not something taped to a fence. A real sign. Bolted to the post. Private property. Mercer Pasture. Limited recorded easement. Authorized utility and emergency services only. No public or HOA access. Chief Randall from the fire department came too. He checked the Knox box. He tested the key. Then he signed off that emergency access was compliant. Sheriff Dean stopped by while the county crew tightened the bolts. He looked at the new sign and smiled. That ought to be clear enough. I laughed. For most people. Dean looked toward Stonebridge. And for the rest? I held up the certified easement copy. That's what this is for. A month later, Stonebridge elected a new board. Their first rule change required every property claim, easement claim, access claim, or boundary issue to be verified through county records before the HOA sent a notice or threatened enforcement. Their second change created a resident document portal. That way, board members could no longer hide behind phrases like legal complexities. Their third change ended emergency votes unless actual emergency services were involved. Tom sent me the new policy. At the bottom of his email, he wrote, "Apparently, because Marlene said so, is no longer a legal standard." I printed that one too, but not for the binder, for the fridge. By late summer, the pasture got quiet again. Grass grew back over the tire tracks. The cattle stopped bunching near the far fence. The cedar post still had a faint scar where Marlene's notice had been taped. I left it there. Some marks are worth keeping. They remind you where someone tried to rename what was yours. Every now and then, a Stonebridge resident still slowed near the gate. Maybe they remembered the story Marlene told them. Maybe they remembered the one that turned out to be true. Most kept driving. One afternoon, a young couple from the back lot stopped while I was fixing a loose board. I recognized them from the county meeting. They had bought one of the Phase 2 homes. The husband looked embarrassed. "We were told this would be an access road," he said. "I know. We didn't know it was your pasture." "I know that too." His wife looked at the cattle, then at the sign. "I'm sorry," she said. "We should have asked better questions." I leaned on the hammer. "Most people trust the person standing at the front of the room." The husband nodded. "That's going to change." I hoped it would. Because that was the part of the story that mattered more than Marlene. People think property disputes are about dirt. They are not. They are about who gets to define reality. Marlene tried to define my gate as an obstruction, my pasture as a corridor, my refusal as danger, her board vote as authority, her map as truth. But a pasture gate does not become public because someone cuts the lock. An easement does not become unlimited because someone highlights it in red. And a woman with a clipboard does not become the owner of land just because she learned how to say community safety with confidence. My grandfather understood that. My father understood that. And I had spent 27 years proving it for other people. That summer, I had to prove it for myself. The old broken lock still sits on a shelf in my barn. Not because I am sentimental about the damage. Because sometimes, a small piece of metal tells a whole story. On one side, there is the cut mark from the bolt cutters. On the other, there is rust from all the years it did its job quietly. That lock never argued. It never raised its voice. It simply held the line until someone crossed it. Then the deed did the rest. And if there is one thing I learned from watching Marlene Whitaker stand in front of the sheriff, staring at a county record she should have read before touching my gate, it is this. Fake authority is loud because it has to be. Real ownership can afford to be quiet. Because sooner or later, someone is going to open the file, unfold the map, read the deed, and ask the only question that matters. Who owns it? If an HOA cut the lock off your private gate and called the sheriff on you, would you warn them one more time, or let the county record answer?